For this video, we will be discussing the crime of estafa in general and estafa under Article 315, Subdivision 1A of the Revised Penal Code as amended. Estafa or swindling under the said Article 315 can be committed in three ways. They are: number one, or the first way of committing estafa, is estafa with unfaithfulness or abuse of confidence. Now, under this first way of committing estafa, we have Subdivision 1A, which is estafa by altering the substance, quantity, or quality of anything of value. Then we have Subdivision 1B, which is the crime of estafa by misappropriation or conversion. And Subdivision 1C, which is estafa by taking undue advantage of the signature of the offended party in blank. The second way of committing estafa is estafa by means of false pretenses or fraudulent acts. Now, under this second way of committing estafa, we have Subdivision 2A, which is the crime of estafa by using fictitious name or falsely pretending to possess power, influence, qualifications, etc., or by means of other similar deceits. Then we have Subdivision 2B, which is the crime of estafa by altering the quality, fineness, or weight of anything pertaining to the offender's art or business. And we also have Subdivision 2C, which is estafa by pretending to have given bribe. Also, we have the crime of estafa under Subdivision 2D, which is estafa by post-dating a check or issuing a check in payment of an obligation. Now, the third way of committing estafa is estafa through fraudulent means. Now, under this third way of committing estafa, we have in Subdivision 3A the crime of estafa by inducing another by means of deceit to sign any document. Then we have Subdivision 3B, which is the crime of estafa by resorting to some fraudulent practice to ensure success in a gambling game. And we also have Subdivision 3C, which is estafa by removing, concealing, or destroying in whole or in part any court record, office files, documents, or any other papers. But most authors have reduced the above three ways of committing estafa into two kinds. Subdivision number 1 is denominated as estafa with abuse of confidence, while subdivisions 2 and 3 are known together as estafa by means of deceit. Now, the word deceit, which means the action or practice of deceiving someone by concealing or misrepresenting the truth, is often synonymously associated with the word estafa. When people hear the word estafa, they automatically think that someone has employed fraud or deceit upon another. While it may be true for subdivisions 2 and 3, I am referring to estafa by means of deceit, it is not always the case with respect to subdivision number 1, which is estafa with abuse of confidence. Deceit, therefore, is not an essential element in estafa with abuse of confidence. Take note of that. Now, what are then the elements of estafa in general? Before we proceed to discussing the various ways of committing estafa under Article 315, let us first take a glimpse of the elements of estafa as a crime in general. First element, that the offender defrauded another either by abuse of confidence or by means of deceit, and that damage or prejudice which is capable of pecuniary estimation is caused to the offended party or to a third person. Take note that damage is always an essential element in estafa, but the damage here must be capable of pecuniary estimation. Capable of pecuniary estimation meaning consisting of or measured in terms of money. Why? Because the amount of the damage is the basis of the penalty for estafa, as provided in the first, second, third, and fourth paragraphs of Article 315 and also in Article 315, Subdivision 2, letter D. What this means is that there is no way by which the court can impose the penalties provided for in Article 315 without the damage being measured in terms of money. That is why the damage as an element in a crime of estafa must be capable of pecuniary estimation. The first kind of estafa, which is subsumed under the first way of committing estafa, which is estafa by abuse of confidence, is Article 315, Subdivision 1A, otherwise known as estafa by altering the substance, quantity, or quality of anything of value. How is this crime committed? This kind of estafa is committed by altering the substance, quantity, or quality of anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. Here are the elements of this crime. First element, that the offender has an onerous obligation to deliver something of value. When you say onerous, it means involving or imposing or constituting a burden, or simply burdensome. Now, this onerous obligation to deliver usually arises in a contract of sale. Why? Because a contract of sale carries a correlative duty of the seller to deliver the property and the obligation of the buyer to pay the agreed price. Second element, that the offender alters its substance, quantity, or quality. Let us go through some examples. Example number 1, alteration as to substance. X, in a contract of sale, promised to deliver 2 sacks of sugar to Y. It turned out, however, that what X delivered to Y were 2 sacks of salt. Clearly, there is here an alteration of the substance agreed upon, because what X promised to deliver was sugar, but instead he delivered salt. Example number 2, alteration as to quantity. X, in a contract of sale, promised to deliver 20 sacks of sugar to Y. It turned out, however, that X delivered only 18 sacks to Y. While it is true that X delivered the same substance to Y, but his fault this time is he altered the quantity to be delivered. Instead of fulfilling his promise to deliver 20 sacks, he only delivered 18 sacks of sugar. Example 3, Alteration as to quality. X in a contract of sale promised to deliver 2 sacks of grade A or class A sugar to Y. It turned out, however, that what X delivered to Y were 2 sacks of grade C or class C sugar. Well, there is here no alteration as to substance, no alteration as to quantity, but there is here an alteration as to quality. Instead of fulfilling his promise to deliver class A sugar, X delivered class C sugar instead. Take note that the mere failure of the seller in good faith to deliver what he had promised will not give rise to estafa under Article 315, Subdivision 1A. Being an intentional felony, there must be proof that the seller deliberately altered the substance, quantity, or quality of the thing to be delivered. Meaning to say, there must be bad faith on the part of the seller to alter the substance, quantity, or quality. Or at the very least, the seller knew that he could not comply with his promise to deliver, and yet he proceeded in pushing through with the contract, creating the obligation to deliver. Also take note that there is no estafa when there is no agreement as to the quality of the thing to be delivered. But there must at least be an agreement between the object or the substance and the price. Otherwise, absent such meeting of minds, there is no contract of sale to speak of. And when there is no contract of sale or perfected contract of sale, the obligation to deliver does not arise. Third element, that damage or prejudice is caused to the person to whom the thing was delivered. Why? Let us go through the example. X, who has already paid the purchase price for 10 sacks of Class A rice, received instead 10 sacks of NFA rice. Here, the damage caused to X is receiving less than what he paid for. Now, being an onerous obligation, the buyer must have either fully or at least partially paid the purchase price at the time the thing is delivered. Otherwise, the person making the delivery is not liable even if there was an alteration of the substance, quantity, or quality of the thing delivered. What is the reason here? The reason here is there is no damage caused to the buyer as he has not yet partially or fully paid the purchase price. Didn't you notice in Article 315, Subdivision 1A, that there is this phrase, even though such obligation be based on an immoral or illegal consideration? What does this phrase mean? This means that the offender is still liable for estafa, even if the subject matter of the obligation is illegal or outside the commerce of man. For example, X, a drug lord, bought 1 kilo of shabu from Y in the amount of 4 million pesos. Y, however, delivered to X only 3/4 kilo of shabu and refused to deliver the remaining 1/4 kilo. This is what? A clear alteration on the part of Y. I am referring to alteration as to the quantity of the thing to be delivered. And Y here is still liable, even if the subject matter of the obligation is contraband, shabu, by virtue of the express provision of Article 315, Subdivision 1A. Question: has Republic Act 10951 decriminalized Article 315, Subdivision 2E? Because prior to the passage of RA 10951, the Revised Penal Code provided for Article 315, Subdivision 2E. But RA 10591, which took effect on September 2017, amended Article 315 of the RPC by adjusting the amounts of the fraud on which the penalties are to be based. Now, while the purpose of RA 10951 was only to adjust the said amounts, you can't help but notice that it also deleted the provision of Article 315, Subdivision 2E, which punishes as estafa the following acts. Number 1, by obtaining food, refreshment, or accommodation at a hotel, restaurant, etc. without paying therefor, with intent to defraud the proprietor or manager thereof. Number 2, by obtaining any credit at said establishments by the use of any false pretense, or by abandoning or surreptitiously removing any part of his baggage from said establishments after obtaining credit, food, or accommodation therein without paying therefor. What I am trying to emphasize is, prior to RA 10951, we have this kind of estafa which punishes these acts. The effect of such deletion is the repeal and decriminalization of Article 315, Subdivision 2E. What this means is that criminal liability under this deleted penal provision is therefore obliterated. This also means that the crime no longer exists, and it is as if the person who committed the same never did so. For example, X was charged for violation of Article 315, Subdivision 2E. Let's say for under any of those acts I just mentioned. Subsequently, Congress passed RA 10951, deleting the said penal provision. Now, the case filed against X will then have to be dismissed, for a person cannot be prosecuted, convicted, and punished for acts that are no longer considered criminal. This is based on Article 22 of the Revised Penal Code, where a penal law is given retroactive application since it is favorable to the offender, provided that the said offender is not a habitual delinquent. In addition, Section 99, which is the repealing clause of RA 10951, states that all laws inconsistent with RA 10951 are hereby repealed, while Section 100, which is the retroactive clause of RA 10951, states that it shall have retroactive effect to the extent that it is favorable to the accused or person serving sentence by final judgment.